Welcome back, everyone, to the show. I'm very happy. My attorney colleague, Russell Knight, is back with us today. Hello, Russell. Thank you so much for joining us.
Thanks for having me.
So Russell is an expert in family law. He's practicing in Illinois, in Florida. He has dealt with hundreds and even thousands of cases already. And he specialized in all kinds of matters in family law, especially divorce, custody, kids-related issues, right? Visitation rights, and all things that are, in a divorce case, what you can think of. Today, we want to focus a little bit more about what is specific in Florida, right? We have 50 states, so Florida is one of these. Maybe Russell can also tell a little bit about his experience in Illinois. We would like to start with, what is the divorce case usually in Florida? So maybe you can tell our listeners who think that there are very certain specifics when to get divorced. Do you need a reason to get divorced in Florida, or is it pretty much irrelevant?
Yeah. In Florida, the first question is, are you able to get a divorce in Florida? And that requires being a resident in Florida for 6 months, and they make you prove it. They make you they take a photocopy of your driver's license to be sure that you, in fact, have been living in Florida for 6 months. They want to see a date 6 months before the filing date on that driver's license to prove you're doing it. After that, they don't really ask questions about why your relationship broke down. It's called no fault. They say it's not important. The only thing that's important is the best interest of the children and that your assets are equitably divided and your support or who anyone's support ends up following the guidelines that are listed.
Yes, so it's a no default state, right?
Exactly.
Compared to other states that that you need to prove actually what happened. Or a lot of clients also come to us and they say, well, my spouse cheated on me, or there was like certain reasons. What do you say to those clients, because it is pretty much irrelevant in Florida to get divorced, or they think even they can get a compensation of some sort, right, in Florida divorce court for those kind of reasons? What do you say to those clients?
They don't, the system does not care about how terrible your spouse is or was. Does it color your case? Certainly. Does it let me know your motivations of why you're trying to get what you're trying to get? Because not everything follows a cookie cutter pattern. But for the most part, it doesn't matter. And here's the funny thing, I think. Most clients do not tell me why their relationship broke up. It's who knows, it's over now. So I'm just focused on wrapping it up for them.
Yes, and also what is a little bit, problematic is you only hear one side of the story, right? Because the client that comes to you, they present themselves in most cases as, the good one. Or they hardly acknowledge that, some people are just self-reflective enough, right, to do that. But a lot of clients say, well, it was my spouse as a narcissist, like a word that comes up so often, narcissist. Right? This is like as if so many people were actually narcissists. That's what you think when you have all those clients coming to you and claiming that from their spouse. But they also say, well, this person was, manipulating me into that marriage, or was like emotionally abusing me. There are a lot of terms that come up very often, and it's very hard to prove it because we were not part of that marriage. We were not, visitors at home, right? We don't have like actually an insight. So it really doesn't matter to us attorneys and also to the court what happened in that marriage, right? Because if they come to you, it can matter when it comes to custody. Like, would you like to explain a little more about what happens if your client comes to you and says, well, it is relevant how my spouse is actually, right? Because we have minor kids and we need to figure out how to parent those kids.
Well, Florida uses a bunch of factors that the court's supposed to use to determine who's going to have parenting time and who's going to have decision making. And if someone is exhibiting wild behavior that does not prioritize the well-being of the children, that's certainly going to fit into one of the factors that the court's supposed to look at and can be brought to the court's attention. The question is, how much is that going to weigh? If the person is a giant jerk, that's terrible, but a jerk parent is probably better than no parent in the court's eyes and will still allocate, Florida's a very 50-50 friendly state. That's the default.
Yes, because a lot of people tell me, well, they want custody. First, you have to correct them and say there is no custody anymore, right? There's like we talk about, the time sharing model. right, and parenting plans. So it's, as you said, do you welcome that change, that it's mostly the court says the parents should parent them 50-50 if they can, and only in exceptions, one parent should gain a lot more time with the kids.
Yeah, only in exceptions do they have one parent. The biggest thing that prevents 50-50 is work schedules.
Yes.
If somebody is working at a restaurant, for example, like how do you, when you open your shift at 4 p.m. and you come back home at midnight, you're just not going to have a 50-50 schedule. You're going to have to figure something else out. That is the bigger factor than someone being, let know, an awful human being. As shocking as this is, it's really it's kind of logistics, frankly, in scheduling the parenting time more than anything.
Yes, yes. Would you like to also explain a little bit more about people who are afraid of, they have to pay a high child support? For example, they have 3 or 4 kids, they split, the man is working a lot more, right? So naturally, he cannot take care of them 50-50, so that means he would have to pay child support. But, of course, it's, he has to manage that, right? He has to be prepared for what he has to pay monthly. In Florida, do you have any, case law where you could say this is like, a rule of thumb, like prepare for, those matters when it comes to paying for your children?
Well, what I tell people to do, because I don't like to be the bearer of bad news all the time, is that there's a million calculators online where you can put in how many overnights you plan to have with your kids, what your income is, what you think your spouse's income is, and what the child support would be under those circumstances. Because it's usually a hard pill to swallow. And yes, the more time you exercise, the formula does reduce your child support. But at the same time, like having kids is expensive. They eat, they do activities, they need something on an immediate basis. And child support doesn't cover any of that stuff. So if you have the kids more, you're still going to have more expenses. My philosophy is if you want your kids 50-50, get them 50-50 because you want that. To do that to reduce child support seems asinine, frankly.
Yes, exactly. That's the wrong motivation, right? It's just like to take revenge on the other spouse, to say, well, I want to take away, the children 50-50, right? So that the mother doesn't get to parent them 50%. And then they try to hire someone else to take care of the kids because they don't have the time or they're not really willing to put in the effort for their kids. So I'm not saying this is mostly men or mostly women. You can't really, make it like, a general accusation right there. But in a lot of cases, they really think about, I want to pay as little as possible because everything else is so expensive, like living costs in the US, right?
Yeah.
Everything is just like super expensive. So they want to limit that. And of course, they don't want to pay as much as they have to if they don't see the kids as much. But it's the wrong motivation. As you said, you have to do it for your kids because you need to parent them. You're the mother or the father, and so you have the responsibility forever, right?
Yes.
So what would you say in other cases where the spouse asks for alimony? Is there something that you would recommend to your client, to get prepared before the court?
One of the things I strongly recommend is something called an alimony buyout in lieu of, because the assets are going to be split 50-50 default. That's the marital assets at least. And then the alimony is kind of a big question mark because it's based on needs and income, and those both fluctuate all the time. So I say, wouldn't it be easier to just say, instead of me keeping 50% of the assets, maybe I'll just keep 40% or 30%, and then the alimony thing can go away. And
Yes.
that's as good as money in the bank for both people. So I
Yes.
strongly encourage that. The only problem is if it's a long-term marriage, and then let's say you're going to have to pay 12 year, 12 years of alimony for $1,000 a month. That's 144,000. Well, you don't give somebody, if you're giving them the money right away, you don't give them the whole 144,000 because there's a discount rate. You would have probably 144,000 paid over 12 years is probably really worth, you know, 70 or 80 or something. It depends on what the interest rate is. But getting the other person to understand that, it's difficult because if you get hit by a bus tomorrow, you don't owe any alimony at all after that.
Yes.
So again, a buyout solves all those problems. It solves, will they pay me? Will their job continue? Will they get sick? Will they get hurt? Will they just stop paying? Will the others decide receiving, get married, and then cut off their alimony? There's so many variables that can happen. And most of the time, the solution is just pay me now.
Yes.
Why not? You have 50% of the assets.
Yes.
Use the money.
Yes. Also, like a follow-up question, what we usually get is, can you go back to court and adjust the motion, adjust like a parenting plan, and also when it like parenting and child support plan afterwards at any time? Is that possible, or do you need specific, rules for that?
Well, for parenting, there has to be a substantial change in circumstances. They do not want parents running back to court because they're just spiteful or petty. They want to say, I want to see something big has changed. And there's a bunch of examples of what a substantial change of circumstances would be, like a change of schedule for a job would be one. A child maybe, being involved in a special sport that requires a different schedule would be one. But a child that is in a temporary activity that doesn't really impact anything else probably wouldn't be. They leave it to the judge to decide, do you meet this threshold of a substantial change? And if you do, then we can take a look at changing the parenting plan based on what the best interests of the child are now, not back when you originally entered into the order.
Okay, that's very interesting, because a lot of people say, well, from my perspective, there's a huge change, right? So whenever they move to a different country, for example, and then they say, well, we have already like a difference in time. The time difference may be 8 hours, 9 hours, or even more. So that already requires to set up different times for visitation, or different times to have video calls, right? So when parents want to go back to court, we always tell them it has to be substantial, as you said, because otherwise the court might say, well, we don't need to adjust. Right? You as the parents have to make it work. You need to figure it out. And the court is not supposed to, rule everything that you might need, right, in this specific area. You have to work it out, because you are responsible and accountable for your children, right? And the court is only here to help you if you cannot come to an agreement, right? But you should, as you said, you should not overuse the court system, because there's just already so many cases that have to be processed, right? Okay, perfect. What would you say to new clients that say, actually, we have minor children, right? And we have also assets, but we need to, split that somehow in the divorce. Can you tell them, well, you can, sacrifice a little bit of certain assets, and in return you get a higher alimony support or something like that? How would you? Is that a possible? For people who say, well, I cannot just pay you out of the house, because otherwise I have to sell the house, right? That's just the solution.
Yeah, that's exactly right. So they can't, the buyout usually ends up being, if there's so many things to think about. For example, a 401k, it might say that there's $400,000 in your 401k, but you still have to pay taxes on that. So it's not really 400, it's really 300. The same goes for a house. There might be capital gains taxes on top of that. It's not really worth it. And you still need a place to live. So the buyouts don't really happen. And then again, the buyouts can't be done for child support, because the court wants to make sure those kids are eating and have a roof over their head. So when you do a deviation, you have to get the court's permission to do a deviation. And I would be shocked if a court ever said that a buyout was a sufficient reason for a deviation. So things can be changed, but the rule of thumb is you have to have a good reason for changing them.
Yes. So is there a possibility that you can, explain to a client, well, we go to court, and you let me, handle all the matters, right? And you're only speaking when I ask you to please speak, but it's in your best interest that you let me handle everything. Is there a specific reason why you would tell them, ask the court not to have a personal hearing for your client, or is there in general always a personal hearing that your client has to come before the judge in person?
Well, in general, if they're taking if they're taking testimony, yeah, they have to be there. If it's, if it's not taking testimony, I guess you could not be there, but the judge has eyes. They can see who's there. They can see who's interested in their own case. It's easy to rule against somebody that's not there. That's been my experience.
Yes. And also it could influence them, subconsciously to say, well, if it was that important, it's about their kids, the person would be there. The person would just book a plane ticket like they do for going on holidays, right? They would just come and do it, even if it's abroad, even if it's on a continent. Well, if it's, important enough, you do it. You find a way, right? Okay, perfect. So a lot of questions are actually covered by that, like, the first questions that clients have when they're coming to you, right? What would you tell? How would you explain the principle? The principle of, is there any indication when there is domestic violence involved in a divorce? Does it have any result, any influence on the outcome of a divorce or outcome of custody when there's like accusation of domestic violence?
Well, yeah, domestic violence can change everything. It can kick someone out of a house. It can affect their capacity to it can affect their capacity to parent their children. It can affect their job if they work with their spouse or near their spouse, then they can't go to work, or like even if they see their spouse in the grocery store, like it becomes a problem. So domestic violence ends up being like a gigantic, how do I want to say it, like a like a problem that perpetuates itself throughout the entire case, and it's extremely sad when it happens. And there's also accusations that sometimes are not substantiated, and it can ruin someone's life at the same time. So it's any case with domestic violence accusations or incidences, it makes the case almost unmanageable. Like you can't even do a mediation if there's domestic violence, because why would you want to be in the same room with the person that's your abuser?
Yes, exactly, and that's also that we happen to get also cases where the accusation is quick in outspoken, right? Domestic violence could be emotional abuse, could be psychological, doesn't have to be physical abuse always, right? And people are quick to say that just because they at some time they didn't feel comfortable in the relationship, they were unhappy, right, with something. And it's quick to say, I was manipulated financially, emotionally, right? So you have to be careful as a counselor too, to say, well, do I really bring that to the court? How substantial is that, right? And is it weakening our position in the end, right? Or is it really beneficial for our position, what we want to achieve, right? Even if the client says we need to, tell this to the court, well, maybe not, right? Because
Yeah.
that's not what you want to achieve, and it's actually because also judges are very sensitive to if someone plays the victim, right? And someone is, actually honest and true, right? And when they see the person in person, and they speak to them, and there's a hearing, the judges are very sensitive to, who is actually over exaggerating, and who is just, who was really abused. So I would be very careful in, just bringing that to the court at each and every single time if it's not relevant for your case and if it's actually harming your case even more.
Yeah, because domestic violence petitions are brought on an emergency basis, they're usually your first impression on the judge, and you never get a second chance to make a first impression.
Yes.
And whether you are the victim or the accused, it is not probably a person's best look when they're trying to figure out how they're going to divide their assets and manage their co-parenting when there's this big, fat, horrible issue in front of you. But that being said, like it happens and it has to get addressed.
Yes, yes. So as a last topic, would you like to explain to clients the principle of equitable distribution of marital property? Because a lot of people get it wrong. They think it has to be equal, right? It has to be, we have to get the same share, right? If we don't have just saying they don't have a prenup. If someone doesn't have a prenup, because if you have a prenup, everything is amazing, right? Because you don't fight about it. That's the best solution. We can recommend anyone anywhere in the world to have a prenup, because if something happens, you are protected and your spouse is protected as well, and you don't fight about anything in court. That's what we love, right? People have prenups. If they don't have prenups and you need to fight about everything, or your client needs to fight about everything, how would you explain to them that principle that they probably don't get an equal share, but it has to be fair in the end?
Well, it has to be fair, and then if it isn't equal, then the judge has to explain in their findings why it wasn't equal. But at the same time, like you're negotiating, you can negotiate for anything you want. So if you really want to keep the China hutch that you bought during the marriage and it's marital, you're probably going to have to give up something that has a greater value, either objectively or subjectively, to your spouse. And so there's no requirement for 50-50 so long as you agree. Some courts do require you to attach a spreadsheet, a balance sheet, so they can verify that it's 50-50, because it is very likely that the moneyed or more sophisticated spouse will say, well, I'm going to let you keep all your vintage Beanie Babies, but I'm going to keep all the real estate. And
Yes.
then and the unsophisticated person's like, well, if you say so, because there's a lot of power dynamics like that out there where there's couples that one party has no idea about the finances. That's so common.
Yes, and that's very common actually. We see a lot of like when married men and they don't have the equal, like not even equal professions, or they're like coming from very different levels also. Then the woman's just like, well, I don't know even what he's, sometimes they don't even know the real job. They don't even know what the person is really doing every day. And it's just impossible, right? And if you get divorced, well, this person can tell you anything. And you have to be very careful, and you have to get an attorney that is fighting for you and not just, accepting whatever the other party says, right? Because it's very, as you said, it's very dangerous, and there's a knowledge gap. Then how do you make sure that this person is not, taking advantage, right, when it comes to the divorce?
Well, they have to have representation. Like the lawyer has a duty to make sure that they're getting what they should get and not just what they want to get or what they think they deserve.
Yes. Mm-hmm.
Some people are so full of shame of the divorce that they lacerate themselves with, a horrible deal, and it's terrible. So a lawyer's job is to say, yeah, I get it. You feel bad and you should have gotten this divorce is a terrible reflection on everybody involved, but in the end, you should be walking away with 50% and the support should be paid as the law states. And you don't have to take a haircut just because you desperately want this to be over or
Yeah.
you're afraid of some other type of penalty or litigation that will occur.
Yes. So we always, what we do when clients come and don't have a prenup, we tell them, well, you pretty much don't have any insurance, right? That's what it is, because the prenup, it's only for the worst case. Like best cases, you don't never need the prenup in your life, right?
Yeah.
But if you get divorced or something else happens, right? If you said every marriage ends, it's either by death or by divorce.
That's right.
So that's pretty much everyone is facing that, right? It's either one or the other. So when we tell clients get a prenup before, as long as you're still on good terms, get a prenup, because it's super important if you get divorced to not get into a messy divorce. If one wants to fight and wants to drag it on over years, he or she could probably do that, right? And you could delay the whole process. What was, from your experience, the worst example of not having a prenup and not having a proper legal counsel, and being in divorce for years? Do you have a benchmark where it was like 7, 8, 9 years of
Yeah,
divorce?
sometimes they get divorced and they're in court the next month. That's way more common than you think. If there's children involved, that's and there's not an and there might be an order, there might be an agreement in theory, but they're still not agreed, they'll still go back to court. People really love their kids and want to do the best for their kids,
Yeah.
and it only takes one person
It's
to frustrate that, and they have to be back in court. And even the money issues, let's say you're ordered to pay something, but you're self-employed. No one's garnishing your check. You're
yeah,
just supposed to pay. And if you don't, well, then you have to go back to court. Even if you do work, there's some people they change jobs every year. So imagine they might even want to pay, but they're like, oh yeah, I forgot to tell my employer. It's a nightmare, and they have to keep going back. So it's like a bad penny. These people, nobody changes. A leopard does not change his spots. So if you had issues with the person while you're married to them, you're probably going to have issues with them after you're married to them.
yes, and also what is very, very like a good benchmark, when you get married and you have problems with someone, that problem is going to accelerate. That problem is just going to get bigger and bigger when you come to the end of the relationship. When you think, well, that's a problem I can look over, and that's not really important, right?
Yeah.
That's going to be probably the reason why you need to get a divorce or why you need to separate, right? So you should never overlook something that is, your own value. It has to meet your own, values in life, right? If it's financial, if it's regarding family, if it's something that you need to make a compromise, it has to be something that is not substantial, right? If you have to make compromises at all, while you should not compromise to even get married in the first place, right? Because people say, well, I will never get remarried, and then 2 years later they're remarried after the divorce, and they still don't have a prenup. And I'm thinking to myself, why in the world would you not have a prenup when you didn't have a prenup in the first place, and you already went through this, nightmare, right? And then add minor children to the whole scenario, and it gets just very messy. What is your greatest tip, or do you have some recommendations for clients that are listening right now and say, I need an attorney, I need you to represent me in Illinois or in Florida? How can I contact you? How would you even advise me to prepare for the first consultation?
What I don't normally do, like, what should I know? Like, you don't need to know anything. I can ask you all the questions. When you got married, how many kids you have, what your incomes are approximately, what things were purchased during the marriage, what is something that you're most afraid of, because that usually reveals a secret issue that has to get addressed. So you don't need to do anything. You could just give me a call. I'm happy to give you some minutes of my time to figure it out. I've been doing this for 19 years now. I can smell what a case is going to be like within 2 minutes. But it'd probably take a little longer than that to get to know the real issues that are going on in your particular case.
Okay, perfect. This was an amazing ending. Thank you so much, Russell. It's always amazing to talk to you and spend some time to talk about our favorite topic, family law. Uh,
Mhm.
how can people get a hold of your company in Illinois and in Florida? Do you have like a shortcut in like website or email?
Yes, for Illinois, it's www.rdklegal.com. That's Russell Dale Knight is for RDK. And for Florida, it is www.divorceattorneynaplesfl.com. Just
Mhm.
reach out to me there, and I'll be happy to schedule an appointment with you and chat and figure out what you need to do for the next steps of your chapter.
Thank you so much, and talk to you very soon. Thank you.
Thank you. Bye bye.